we're going to take up Mr. Daniels' matter, then we'll come back to you, and then we will take up the Delgado matter. So Ms. Jefferson, or Ms. Smith, if you could wait go back to the waiting room for a few minutes, we should get back to you probably in, I would say, 10 to 30 minutes.
Okay, thank you.
All right, Ms. Truitt, can you bring Mr. Daniels back? Mr. Daniel, Mr. Marin, we're ready to move forward. At this time, I believe we've moved everybody to the waiting room, not involved in this proceeding. Counsel, for a compulsory discipline matter, the board asks that you please address proof of service and notice of the hearing, proof of finality of judgment, factual and legal basis for the conclusion that the conviction is an intentional crime, and what you suggest is the appropriate discipline in this case. Would counsel please state their appearances for the record?
This is Luis Marin with the commission.
Thank you.
Lawrence Daniel, the respondent.
Thank you. Mr. Marin, would you like to make a brief opening statement?
Yes. May it please the board. This compulsory discipline case is based on respondent's conviction for securities fraud, a second-degree felony and a securities fraud, and a third-degree felony in the 5th District Court, Cedar-Iron County, state of Utah. We filed our petition for compulsory discipline on March 24, 2021. Respondent was personally served with the petition and notice of hearing on March 24, 2021 by Deputy Terry Christensen, Carbon County Sheriff's Department. Proof of service has been on file since March 29, 2021. In regards of respondent's conviction, on June 8, 2017, respondent was charged by criminal information with the following. Count 1, securities fraud, a second-degree felony. Commencing on or about August 2013 in the state of Utah, the defendant, in connection with the offer or sale of a security, directly or indirectly to Nola Crappie and or Shan Manley, made an untrue statement of a material fact or omitted to state a material fact necessary in order to make the statement made in light of the circumstances under which it was made, not misleading or engaged in an act, practice, or course of business which operated or would operate as a fraud or deceit, and the property, money, or thing unlawfully obtained or sought to be obtained was worth $10,000 or more in violation of Utah Code annotated sections 61-1-1 and sections 61-1-21. This violation is a second-degree felony under Utah law. Count 2, securities fraud, a third-degree felony commencing on or about October 2013 in the state of Utah. The defendant, in connection with the offer or sale of a security, directly or indirectly to Zeros Cefisare, made an untrue statement of a material fact or omitted to state a material fact necessary in order to make the statement made in light of the circumstances under which it was made, not misleading or engaged in an act, practice, or course of business which operated or would operate as a fraud or deceit in violation of Utah Code annotated sections 61-1-1 and 61-1-21. This violation is a third-degree felony under Utah. The case was styled State of Utah Plaintiff versus Lawrence Earl Daniel, date of birth, September 22nd, 1960, defendant. It was in the 5th District Court in and for Iron County, state of Utah. Ma'am, on July 21, 2020, a sentence judgment commitment was entered wherein respondent was found guilty and convicted of securities fraud, second-degree felony, and securities fraud, a third-degree felony. Based on respondent's conviction of securities fraud, a second-degree felony, the respondent was sentenced to a term of 17 days, credit granted for time served. In addition, respondent was sentenced to a suspended prison term of not less than 1 year nor more than 15 years based on the second-degree felony conviction, and a suspended prison term to exceed 5 years based on the third-degree felony. Respondent was also placed on probation and ordered payment of fines. This was in cause number 171500332FS, styled State of Utah Attorney General Plaintiff versus Lawrence Earl Daniel Defendant in the 5th District Court, Cedar, Iron County, State of Utah. At this time, ma'am, I'd like to offer the following exhibits. Exhibit 1, certified copy of the criminal information, styled State of Utah Plaintiff versus Lawrence Earl Daniel, date of birth, September 22nd, 1960, defendant in the 5th District Court in and for Iron County, State of Utah. Exhibit 2, certified copy of the sentence, judgment, commitment, entered in cause number 171500332FS, styled State of Utah Attorney General Plaintiff versus Lawrence Earl Daniel Defendant in the 5th District Court, Cedar, Iron County, State of Utah. Exhibit 3, it's my original affidavit attesting to the fact that Lawrence E. Daniel is the same person as this person identified as Lawrence Earl Daniel in the underlying criminal case. Exhibit 4 is a true and correct copy of Utah Code annotated section 61-1-1 and 61-1-21 under Rule 202 of the Texas Rules of Evidence, and a simple copy of the cited regulations. Exhibit 5, ma'am, is an original certificate from Blake A. Hawthorne, Clerk of the Supreme Court of Texas, dated July 7th, 2021, indicating that respondent is licensed and authorized to practice law in Texas. Exhibit 6 is certified copy of respondent's prior disciplinary judgments. At this time, ma'am, I would like to offer exhibits 1 through 6.
Mr. Daniel, do you have any objections to any of the exhibits offered by Mr. Marin?
No objection.
All right, exhibits 1 through 6 are admitted.
Ma'am, as the members of the board may appreciate from the admitted exhibits and the Utah Criminal Code, which copy was also admitted as evidence, the crime committed by respondent and for which he was charged and convicted by the state of Utah involve serious crimes that require intent or knowledge as an essential element. Actually, the statute uses the word willfully. Further, the crime involved misapplication of property, fraud, and moral turpitude. These are elements required by the applicable rules for compulsory discipline, Texas Rules of Disciplinary Procedure 8.01, 1.06V, and 1.06G. As stated by the Texas Rules of Disciplinary Procedure 8.02, record of conviction is conclusive evidence of attorney's guilt. So we respectfully seek entry of a judgment of disbarment under Texas Rules of Disciplinary Procedure 8.05.
Marin, what is the CDC's position on whether Mr. Daniel's sentence has been fully probated?
Our position, the position of the commission is actually that the crime was actually committed by respondent. He was actually convicted, and it required it was willfully, and it actually complied with both Texas Rules of Disciplinary Procedure 8.02 and I'm sorry, someone's like doing a fire test. And Texas,
I think that's me, I'm sorry.
Yeah, and Texas Rules of Disciplinary Procedure 1.06V and 1.06G. So I think the commission position is that actually the disbarment proceeds.
Yeah, but my question was, is it the commission's position that the board has discretion to either disbar or suspend because the sentence was fully probated, or that we only have the ability to disbar?
Our position is that you only have the position to disbar at this time.
Thank you. Any other board members have questions for Mr. Marin? All right, Mr. Daniel, I had asked for opening statements, but I believe Mr. Marin went into his case, so you may proceed with presenting your case as well. You're on mute, sir.
I believe the instructions were that if I were to testify that I needed to be sworn in. Did I understand that correctly?
Yes, sir.
Okay.
Would you raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony that you give in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. You may proceed.
First, I'd like to direct the board's attention to the complaint. I believe it's Exhibit 1. These events occurred while I was not, if you compare that to Exhibit 5, I was not practicing law at the time. In fact, I was working for an oil and gas company. I was their chief operations officer. I had left that company and started my own company. There are plenty of exhibits. I have not submitted them. I wasn't prepared I apologize. Sometimes I have a neurological condition from the Gulf War. Sometimes I will stutter when I get stressed. So I apologize to the board. So I was not practicing law, didn't practice law from 2013 to 2016. These events allegedly occurred in 2013. I started my own company. I had people requesting that they invest. They were friends of mine. I delayed that. In August of 2013, I was asked to take over a project for the Ute tribe to build a refinery for lots of reasons. I was approved by Oppenheimer out of New York. I went Oppenheimer Private Banking to take over the project, which had been mired in delays. After I was approved to take over the project, and after I had been contacted by a company called June Dively Associates out of Houston, a third-party due diligence company on the project, I allowed one of my friends who had been asking me to invest for a number of years, did all the blue sky disclosures. I did not allow him to invest until I had gotten something solid from the Native American tribe, the Ute tribe in Utah. In fact, in September, we started exchanging. This was in August 2013. In September 2013, we started exchanging due diligence documents. I got a letter of exclusivity with a planned closing in March. In November, along this time, I was approached to enter into a gas supply contract with another company called Enhanced Clean Fuels to build a gas to liquids plant in the Farmington, New Mexico area. Another friend who'd been asking to invest, I finally allowed on November 9th. On the November 11th, I signed a $240 million gas supply contract with Enhanced Clean Fuels. My point is there are documents that prove all this. In January of 2014, I got a letter or a call from June Dively saying that the Utes had canceled the refinery project. In August of 2014, 14, the price for natural gas dropped from approximately $4 a 1,000 cubic feet to $1.82 a cubic feet. The price of oil dropped from $100 to $20, and the supply contract was killed. I never intended to defraud anyone. In fact, in his closing arguments, which I could provide, which I haven't, I do have the transcript, the prosecutor stated he did not have to prove intent. There was no proof at all that I ever intended to defraud anyone. The market just fell apart. During the process, I offered to pay restitution, even though the Blue Sky document said I was not responsible. I placed the restitution in the prosecutor's, in my attorney's trust account 18 months before trial. The prosecutor never told the complaining witnesses that I had offered to pay restitution. Again, in the closing arguments, he stated that he did not have to prove intent on these crimes. In fact, he never did prove intent. I didn't intend to defraud anyone. I waited until I had substantial agreements before I accepted anybody's money that I was accused of defrauding. I never made the Blue Sky disclosure specifically state this is high risk. With respect to an intentional act, an intentional crime, there was no proof at trial, and during closing arguments and throughout the trial, the prosecutor stated that he did not
Ma'am, I have to object.
Your objection?
He's actually saying what the prosecutor said, so that would be actually hearsay. He did not provide any evidence of it. He did not provide any records, so that would be our objection.
Overruled. Thank you. You may continue, Mr. Daniel.
Thank you, and that's why I wanted to continue it, because a lawyer representing me at arm's length would have done a better job preparing for today and submitted the documents of the $40 million 10-year supply contract, the documents of the exclusivity agreement with the Ute tribe, the documents demonstrating the validity of these projects, and the transcript from the closing arguments of my case.
Mr. Daniel, this is Michael Gross. I was wondering if I could ask you a question regarding Exhibit 2. Could you pull that up, please?
I'm having difficulty on my computer, but I believe that is the judgment, correct?
That's correct, yes. I wanted to clarify some things with you in this. On the first page at the bottom, it talks about your sentence.
Yes.
And then on the second page at the bottom, it talks about your probation.
Yes.
And I see that under the probation discussion in your judgment, it says that you were to serve 17 days in jail. Was that as a condition of probation?
Yes.
Okay, thank you, sir.
And the sentence was fully probated. I have completed all terms of my probation. In fact, I had a hearing on the 27th, a few days ago, I had filed a motion for two things. A motion for early termination, as I've completed more than 1/3 of the probation. And I have filed what's called a 402 motion in Utah, which is a reduction of my sentence, which can be reduced up to 2 levels, which would make them misdemeanors. Those motions are pending. I didn't bring that up, but that would be important to this hearing to determine if I've been released from my probation. I know the judge who now has my case, a different judge.
And you said it was fully probated, correct?
Correct.
Okay, thanks, sir.
Mr. Daniel, I have a question.
Yes.
And you said you had a hearing, how many days, a couple of days ago?
On the 27th.
Okay. Who was representing you in that hearing?
Well, first of all, I thought I was going to be pro se, and then an attorney from my attorney's office out of Salt Lake appeared. I was not allowed to speak at the hearing. Her name is Gabrielle Mina, is the one that appeared.
Okay, and how many days beforehand was she made aware of to appear on your behalf?
I don't know. I didn't know she was going to appear at all until the hearing itself.
Who provided the evidence for your counsel there to provide to the court?
At the hearing a couple of days ago, or the hearing?
Yeah, a hearing a couple of days ago.
No one, because she didn't even call me and speak to me, but prior to the hearing. She didn't even know that I had filed motions, because I had done it pro se. I filed motions previously to delay imposition of the incarceration because of COVID. I have, of my many Gulf War illnesses, I have COPD. So I don't, I'm very cautious. So I waited until I asked the court to wait until after I got vaccinated.
Okay, and my apologies. So you're saying that you filed a motion on your behalf, is that correct?
That is correct.
Okay, so you're saying that in that specific instance, you marshaled the necessary documents, information to provide to the court to make a decision on your motion. Is that correct?
I filed it the day before.
Okay.
Yeah, I did.
Okay. And you're still practicing right now, or are you not?
I have a handful of cases. I have I have had substitute counsel on the cases where I had the potential to get paid. It's a condemned CV case. And so substitute counsel has appeared. On the other cases, a family law case, there's a case out of JP court that's on appeal that's also probate, that the defendant appealed to the county court. That case was heard fall of 2019. It's still on appeal at county court. That's a pro bono case. There's a family law case in Hays County that's pro bono that I've represented the party since, I want to say, August of 2018. And then I have another pro bono case out of Bear County on an estate that I have been representing the party since 2018, March of 2018. So that's the only law that I practice. I don't take new cases. I don't take any clients' money. I haven't taken clients' money since COVID.
And my apologies. When was the last time you appeared on behalf of a client in a court, either virtually or in person?
Virtually, it was two hearings in May on behalf of the probate client in Bear County. We have been waiting for a ruling in that case. We've all submitted proposed judgments. It's a case to determine heirship, and I represent a party who we claim there's marriage without formalities, which makes her an heir as the spouse, surviving spouse. Those orders, the judge has not made their ruling. The last hearing, I want to say, was around May, was the end of May, before Memorial Day.
And you were ready to make arguments just in case the courts were going to ask you any questions there. Is that correct on your behalf of your client?
I did. I protected my client's interest. I brought the client here. She would testify that, yeah, that I did an amazing job. I mean, the court asked us to submit an order, and I did.
Okay, but you're saying for this hearing this morning, you were referencing documents and information that weren't necessarily in our record, but you weren't ready to provide those documents here on your behalf in this hearing?
To be honest, yes, sir, that's true. It's a very difficult thing to explain, that when it comes to my clients that I care about, I can zealously defend and or prosecute their claims. It is an unusual, which I'm working through in therapy. I saw my VA counselor yesterday. It's when I don't know how to describe it. When it comes to my own self, it's paralyzing.
Okay, thank you.
Mr. Marin, do you have any questions for Mr. Daniel?
Yes, Mr. Daniel, can you please explain the board what was exactly the terms surrounding the 17 days you were in jail?
There was every hearing in the matter prior to me obtaining an attorney was at 8:30 in the morning. I live in the mountains of Utah, about 3.5 hours from Iron County, Cedar City, Utah. I appeared, I apologize. Every hearing was at 1 p.m. There was a hearing at 8:30. I showed, I don't remember, early January of 2019, I showed up for the 1 o'clock hearing, and it was at 8:30 in the morning. I had missed it. I called the court clerk from the court building. There's these small rooms, consultation rooms outside the courtroom. When I got home, there were deputies waiting to arrest me. The prosecutor has particular animus towards me. I'm still not sure why. But yeah, I got arrested in January, I want to say 2019, could have been 2018, could have been December 2017. I spent 3 days in jail because he wanted a $15,000 cash bond, even though I had lived in the state of Utah for 20 years. I lived in Iron County for 17 of those 20. My wife is a school teacher. We had connections, but yet he wanted me arrested. I spent 3 days in jail. So of the 17 days, 3 days had already been served. I then was presented myself in June to the Iron County Detention Center. I was supposed to do 14 days. I did 11 days in isolation, spent 1 day in general population, and was released after 12 days for good behavior.
So you would say that because I'm just reading from Exhibit 2, and you would say that the 17 days of imprisonment you were convicted of, that was also part of the probation?
Yes.
Okay. Thank you, sir. No further questions.
Does anyone from the board have questions for Mr. Daniel? Mr. Daniel, do you have anything else to present?
I don't believe I have any further evidence, Your Honor.
Any further argument?
I do, if you would like me to make my closing argument, or would you like Mr. Marin to go first?
Well, Mr. Marin, do you have any other evidence to present?
No, ma'am. I would like to say a final words, but that's about it.
Okay, so Mr. Marin, proceed with your closing argument.
It's not more of a closing argument rather than actually explaining. We actually read from the sentence that the 17 days of imprisonment were outside the probation of the sentence of the court. So that explains why we requested a disbarment in this case under 8.05. So being that the 17 days also fall under the probation, we would actually say that this sentence is fully probated. In that case, we would be agreeable to the panel granting an order under 8.06 instead of 8.05.
So just to make sure I understand it, it's the commission's position that they agree that the sentence was fully probated.
Yes.
Okay, thank you. Would you like to say anything further in closing?
No, ma'am.
All right, Mr. Daniel, we'll hear your closing arguments.
Briefly, Your Honor, a couple of things. One, this crime, these crimes did not include intent, did not involve intent, and were not proven to have shown any intent to defraud. That is a crucial element, that it was an intentional crime, and the evidence at the trial court and the arguments of the Attorney General refute that it was an intentional crime, that it was just a violation of the statute without proving intent. Those were his exact claims in closing argument. Secondly, I would assert that my sentence has been fully probated. I have actually completed enough to be released from probation had I've been able to move forward with my motions. On the 27th, I would likely have been released from probation. I will pursue those motions further pro se. I don't think that my interests were best served by the attorney appearing without speaking to me, without knowing that I'd filed motions. And yes, it is difficult for me to represent myself. I know that once the court starts, as today, that I tend to do an adequate job representing myself, but it is overcoming that paralysis from my PTSD and depression that make it difficult for me to adequately prepare as I would for a normal client. I am a good attorney. My client will agree with me. My last year of actively practicing law, I was a member of the pro bono college. I always devote a significant amount of my time. I live off my VA disability and my wife's teaching salary, and that's what allows me to do these cases pro bono. But as far as the assertion from the bar goes, there was no intent. I have documents to prove it. I haven't submitted them. The closing argument of the prosecutor said he didn't have to prove intent, and my sentence was fully probated.
Yes, Mr. Marion.
Yes, I'd like to add something as a final comment. I mean, we do not have any of the comments of the prosecutor regarding willfulness here and on the crime committed by respondent. We do have evidence that respondent committed a crime. We have evidence of what actually the crime was. And I'm gonna read from section 61-1-21, it's penalty for violations. All the crimes committed by respondent actually involve intent. Otherwise, he would not have been given the sanction he was given. First, I'm reading from section 61-1-21, number 1, a person is guilty of a third-degree felony who willfully violates. And then it says A, B, and C. On number 2, it says, subject to other provisions of this section, a person who willfully violates section 61-1-1 is guilty of a third-degree felony. B is guilty of a second-degree felony. Those were actually the felonies convicted of. And point B, a person who willfully violates section 61-1 1-1 is guilty of a second-degree felony if, and it continues, and then it goes to number 4, a person who willfully violates section 61-1-1, and it's a very long part I'm not going to read to you due to the time constraints, but actually we do have evidence of the crime. We do have evidence that respondent committed it. We do have evidence that otherwise, if it was not willful, otherwise he would not have sentenced in this case. So the commission position is that the evidence is clear that this case was intentional.
Mr. Daniel, would you like to respond to that?
I would ask for leave to file the transcript of the closing statement of the official transcript of the closing statement of the prosecutor. Utah's a unique animal in this world. But I would ask leave to file the 2 documents or 3 documents that I discussed in my testimony, the due diligence documents, the letter of exclusive intent, and the contract with Enhanced Clean Fuels, the gas supply contract, plus the transcript of the closing argument of the prosecutor.
What is your response to the commission's argument that it doesn't matter what the prosecutor said in closing argument? What matters is the elements of the crime for which you were convicted?
Your Honor, I would point out that we're talking about Utah, which is, I will just say that the criminal justice system here is not only interesting, but an animal to which I'm not accustomed. If the prosecutor says that in their closing argument that he does not have to prove intent, that would clearly demonstrate to the board that even the prosecutor did not consider or that the prosecutor believed that I had no intent. I mean, why else would the prosecutor state in their closing argument that they did not have to prove intent? Because in some places in Utah, particularly rural places, the prosecutor says this person did it, and the jury says guilty, and even though the prosecutor said in closing arguments, which my attorney objected, which the judge did not sustain, that these crimes required intent, but the prosecutor said several times that they don't have to prove intent. And if this is an intentional crime, and if you're going to take away what remains of my dignity and my livelihood, I would think that would be important.
How long would it take you to submit the documents that you want the board to consider?
I could have those by the close of business today.
I'm going to grant your motion for leave to submit additional documents by close of business today. Mr. Marin, the commission can have until the close of business Monday, if that works for you, to file any objections to the evidence. And then we'll consider them as appropriate. Is that agreeable?
Let me get, if I'm correct, I mean, he's gonna have until end of business today to submit the evidence, and then we will have until the end of business of Monday to object?
Yes, if that gives you enough time.
Yes. We can do that.
Okay. Does anyone else have any questions, either for Mr. Marin or Mr. Daniel? Any closing remarks from either counsel? All right, the board will take this matter under advisement. Thank you, Mr. Daniel. You are excused.
Thank you, Your Honor.
Okay, let's take up the matter of Ms. Jefferson Smith. Can you bring her back in, please? I should have asked before we started. The board members need to take a quick break before we get started.
Kelly, could we take a 5-minute break?
Of course. Ms. Smith, I apologize. We're going to take a 10-minute break and we will resume at 10:20.
Thank you.
Okay.